Nau mai haere mai ki te hui e tēnei rā, maku te karakia. Tuia, tuia ke runga, tuia ke raro, tuia ke roto, tuia ke waho, tuia te here tangata, ka rongo te pō, ka rongo te ao, haumi e, ui e, tāi ki e.
Is that better? Anyway. Welcome everybody. I'll start again. Welcome everybody to this hearing of Plan Change 29. Before we get underway and we hand over to the council, I just want to sort of just step through the process, introduce the panel, and deal with any health and safety. So the first thing I'll do, I'll come to Ms. Bryan and we'll deal with the health and safety issues. Thank you.
Thank you. Emergency briefing for the council chamber. So please bear with, it's quite a few. During an emergency, all building and floor wardens are identified by orange high-vis vest, so please follow their instructions. If the fire alarm sounds, leave the building immediately by the nearest safe exit route. Do not use lifts. There is a fire exit through the double doors and down the stairs to Trafalgar Street. Meet at the designated assembly area, which is Whakatu Square in the car park. Stay out of the building until the all clear is given. If there is an earthquake, drop cover and hold. Shelter under a solid surface and hold until the shaking stops. Move away from the windows or objects likely to fall. Check on your colleagues. Report any hazards and injuries to staff. Follow the directions of staff. If the earthquake was long and strong, get gone. Always evacuate the building if the fire alarm sounds. If you are evacuating the building because of a long or strong earthquake, beware of falling debris and other hazards en route to the assembly point. Take your personal belongings. The tsunami assembly point is Pikimai, Churchill, away from any structures and large trees. Do not enter or re-enter buildings until you've received confirmation from staff that it is safe. For a medical emergency, there's an AED, a defibrillator, located in the customer service centre near the public toilets. Call 111 and ask for an ambulance. There's a first aid kit in the small kitchen adjoining the chamber. If there is a bomb threat, an alarm will not sound. Staff will advise which exit to evacuate and where to assemble. Take your personal belongings. Do not use cell phones. Suspicious bag or package. So please do not leave bags unattended that might be considered suspicious. If you see a suspicious bag or package, report it to staff member immediately, and staff will report this to Customer Service Centre. Follow the instructions from staff if a suspicious bag or package is identified. Disruption in the council chamber. There is a specific process for managing disruption that the meeting chairperson will be familiar with. If members feel at risk, they should leave the chamber by the nearest safe exit. General housekeeping. There are toilets through the double doors, and there is a hearing assistance equipment available above the agenda table, which includes instructions on how to use. Thank you.
Thank you very much. And just cell phones off, please, or on silent mode. The panel before you, there are four of us, four commissioners. To my extreme left is Commissioner Brand, Commissioner Parsonson, and Commissioner O'Neill-Stevens, and my name is Greg Hill and I'll be chairing it. Commissioner Brand and Commissioner O'Neill-Stevens are councillors. They're sitting here as commissioners, so effectively taking off their councillor hat. I know that there has been some comment about whether councillors should be on the hearing panel or not. My response to that is that this is a policy matter. It is appropriate for councillors to be on the hearing panel. It's even appropriate and okay for those councillors to have made public comments about the plan change, about whether they support or oppose intensification. The issue is whether they have open mind when they're considering submissions to address our delegations, which I'll cover in a moment. I'll talk to both of them. Both of them do that. We'll have an open mind to consider the submissions. Also, there is a panel of four. I have been specifically given a casting vote in the case of a 2-all contest on any matters. And also, if you're interested, we have developed an interest/conflicts register. So each of us have declared our interests in this. So if any party is interested, they can see that online. So hopefully that'll satisfy parties who were concerned about councillors on the panel. It is appropriate. In terms of the delegations, the council have delegated to this panel and set out quite clearly in our terms of reference, we have the power to make decisions on the submissions, but an overall recommendation back to the council, whether the council should approve with modifications or reject the plan change. So ultimately, we are really a recommendatory panel. Ultimately, the council will need to make a decision, but I just want to make it clear that it's this panel that's hearing the submissions and will make decisions on them. In terms of process, today and maybe a bit of tomorrow, if we need that, we're going to have the council team presenting to us, really setting out the council's position. Ms. Anderson is council's legal counsel. She'll be setting out the council's position, and then we'll come to each of the council's other experts and the authors of the Section 42A report. All of these people are experts. We treat these reports as expert evidence, and so they'll be presenting to us their expert opinion on what they think in terms of Plan Change 29 and those positions. They are not here advocating for a council position. They are representing the council, they're presenting their expert view, and we'll treat them as experts. Ms. Anderson is a lawyer, she's advocate, so she can present the council's position on the plan change. Following that, there is a schedule of submitters, and we'll just simply run through that. So tomorrow, after we're finished with the council, there is some expert evidence, mainly Mr. Mark Lyle's clients, and then we start with some other submitters, and we run this week through until Thursday. Next week, we're starting at 1 o'clock on Monday and running into the evening to allow submitters who are unable to come during the day, running that through to Wednesday. And then because of issues around natural hazards and some of the expert evidence that have come through in the joint witness statement, the expert conferencing, there's clearly some differences of opinions between council experts and the officers and the submitters experts. So that is now going to be heard on the 17th, and we are setting up the number of parties who are coming. We sent out the direction sort of setting out that it will be expert evidence, but anyone who was raising natural hazards issues can ask to be present on that day as well. After the 17th, if we have finished all the hearings, the submitters, sorry, the panel will adjourn the hearings and we'll go into deliberation modes. And we'll see where we end up with that in terms of whether we need any further information or we've got sufficient information to develop our recommendation report. In terms of one of my roles as chair is to run a fair and efficient hearings process. Probably one of the most stressful things for a chair is keeping everyone to time. And so that parties are not having to sit for a long time waiting to be heard when they've been allocated a slot. So timeframes have been given to each submitter. Particularly or potentially we've given you what you asked for. Submitters who asked for 5 to 10 minutes, I think we've rounded all those up to 15 minutes so that we've got sort of sufficient flexibility through the day. But one thing I will be trying to do is trying to keep people to time. You don't have to use all your time if you don't think you need it. If you are thinking you might need any more time, can you please see Mr. Forrester here? Mr. Forrester is essentially running the hearings process and he'll deal with any administrative matters that you might have to deal with that. In terms of submitters, the panel can ask submitters questions, as is the panel can ask the council officers questions. There's no cross-examination across the room, so other submitters can't ask questions of other submitters and the council can't ask direct questions of submitters. However, if issues arise and if issues need to come up through me, if people ask, I might redirect questions. So submitters don't need to be under the sense that they might get cross-examined by lawyers or planners or any other experts. And just for those people who are not familiar with the process, there's been a lot of material for this plan change. Anyone who's managed to keep up with it all has done phenomenally well. So we have the plan change itself, that which was publicly notified. It is that in which parties, submitters lodge submissions based on that plan change. Then that gets summarised and there are further submissions. The council officers have then taken all of those submissions and have written what's called the Section 42A reports, addressing the submissions and making recommendations to us about whether those submissions should be accepted in part or rejected, and where they've accepted them or accepted in part have recommended changes to the notified provisions. And partly what we'll work through today is the council will bring us all up to speed with the latest vision, where they're at with the plan change. Some of the more significant changes have been things like the council officers are recommending removing the high density residential zone and bringing in a different process around an accessibility overlay. So parties who have made submissions, for example, opposing the high density residential zone, by all means can come along and say why they support the council or oppose the council in doing that. The fact that your submission might have been dealt with or things have changed should not preclude you from covering off what you think you need to say in your submissions. Because there was some expert evidence and some difference of opinion, and expert evidence is important in this process. We are to rely on evidence in making a recommendation, both expert and non-expert. But in terms of the expert, we directed and ran expert conferencing sessions where the experts were able to get together. Again, arising from that, there have been some agreements and some areas where there's not agreement. And again, there were joint witness statements that came out setting out what those agreements were or were not. They were all online. And following that, there have been a number of addendums to that Section 42A report, which again has set out the positions that each of the experts now holds and their professional opinion arising out of that joint witness. So things are moving along. It's like a funnel, they're getting more refined as we get through. Now, you may agree with those or you may not, and you're perfectly happy to raise those. We're going to, I'll get underway in a moment. We'll just take breaks, I think, when we can find convenient slots. Mr. Forrest, we've probably got time frames scheduled somewhere and we'll just work to find certain dates. Any other question, anything from the panel? And I know this has been streamed online, and so hopefully parties have heard the way we're going to run the hearing. I'll try to keep this as relatively informal as possible, but within the sort of the rules of engagement, I think, which are all the standard ones about one, respect for each other. I'm not going to tolerate personal attacks on anyone, on council officers, anything else. This is a professional process. You may agree and you may not agree. This is the opportunity to put those forward. The panel will clearly hear those and put questions back to you. Please try and attempt to stick to time. Where material has been pre-circulated with expert evidence, and a number of non-expert or lay submitters, we call them, have filed statements. They've all been read ahead of time. What I find is much more beneficial is not for people to read them out, but to summarise them and then engage with the panel over questioning. And again, I'll just keep directing that as we go along. Is there any questions that anyone's got just on process, anything which is unclear, or anyone wants to cover anything off before we get underway? No, that's all good. Thank you. So on that basis, Ms. Anderson, I'll hand over to you for legal submissions.
Thank you. Tēnā koutou katoa, ko Kerry Anderson toku ingoa. I'm Kerry Anderson, a partner at DLA Piper, and as you said, the lawyer for the council in relation to Plan Change 29. You've probably seen, I think last Wednesday, legal submissions were filed on behalf of council, and I thought I might just take 10 minutes going through the key points from those, if that's useful as a starting point. The first part in those submissions really just set out the evidence that council's put before the panel, set out at paragraphs 4 to 7, and the joint witness statements those council witnesses have been involved in. They then turn to purpose of Plan Change 29, which is set out at paragraph 8, which is effectively to give effect to the National Policy Statement on Urban Development, to include provisions relating to natural hazards and better protection of historic heritage, and then the various amendments that are necessary to really enable the intensification proposed through the plan change. Related to that really is the scope of Plan Change 29, and I'd say that's quite an important issue to think about, because obviously that defines the limits on how much you can change the plan change as a consequence of submissions. And there's really two parts to scope, I'm sure, as the panel is aware. One, scope of the plan change itself. So what was it proposing to change, the extent of the plan change? And that arises because submissions have to be made on the plan change. The second part of scope is there a submission providing the ability to make the change? And there's various legal tests associated with that. And then in addition, there's an ability to make consequential amendments where those are foreseeable from the submissions that have been put before the panel. The details of the legal scope test are set out in the legal submissions, and then probably in a more detailed way in Appendix 2 to Ms Morgan's 42A report. That was a legal memo that I had done really to give the council officers the scope test to have a think about as they were writing their 42A reports. So there's the case law and a couple of examples of scope in that Appendix 2. For the purposes of determining scope for Plan Change 29, I think it's important to have a think about what is subject to change under Plan Change 29 and what isn't. This is for the first part of the scope test. And you'll see at paragraph 18 of the legal submissions, I've set out what the Section 32 report said about what is within scope of the plan change. And it was pretty clear in there that it was altering provisions only in certain zones. So the residential zone, inner city zone, suburban commercial zone and industrial zone. The other zones in the NRMP are not subject to change, so rural, open space, recreation and conservation. And then it was also pretty clear about what wasn't subject to change. And that's also set out at paragraph 19 of the legal submissions. And that was, it didn't involve changes to the RPS. It didn't include new growth areas outside of existing commercial and residential zones. And it didn't enable intensification in areas subject to natural hazards. So that's a very brief overview of what's in and what's out. The legal framework was the next topic dealt with in the legal submissions, or the plan change tests as we call them. And you're probably well familiar with those. They're set out in the legal submissions in shorthand, and then in Appendix 1 in the more detailed list from the case law. And effectively those are taken from Section 72 to 77 of the RMA and Section 32. While there's a detailed list, the ones that seem to commonly float to the surface tend to be the requirement to give effect to any relevant NPS, the requirement to give effect to the RPS, I guess the sort of obvious planning rules about policies should implement objectives, rules should implement policies, and then there's a various list of things you need to have regard to. And obviously Section 32 assessments about efficiency and effectiveness sit in there, and you will have seen I tend to call it just the most appropriate test in terms of encapsulates all of those things as ultimately the decision that gets made. The next few topics in the legal submissions were really in response to specific questions from the panel, and the first was the role of the RPS, and the panel had asked specific questions in your 12 August memorandum, and really the key points around the role of the RPS as set out in the legal submissions are that Plan Change 29 has obviously got to give effect to that RPS, give effect to, based on the King Salmon case law, means implement, and Plan Change 29 must also give effect to the NPS. We're focusing on the NPS UD, so must give effect to that one. Whether or not the RPS has given effect to the NPS is not a matter in my submission for the panel to determine. The RMA doesn't require the council, the regional council, to make changes to the RPS before a territorial authority makes changes to its district plan. But just because Nelson is a unitary authority, it doesn't change that position. So what the RMA requires is the panel to consider the RPS. Does the plan change give effect to that? Then the phrase, you look up the line to the higher order documents, the NPS, and make sure that Plan Change 29 gives effect to those as well. If there are tensions between them, probably everyone's heard the King Salmon case law phrases, then they have that test about making sure you set out what those tensions are and make a thorough attempt to try and reconcile them. And if there are still tensions between, say, the RPS and the NPS, or between provisions in the RPS or the NPS, then the higher order documents can be used to resolve that. And you'll see the council's evidence is that Plan Change 29 does give effect to both the RPS and the NPS, and I think Ms Morgan will be addressing that in her 42A report summary. The next question the panel asked about was the future development strategy and the relevance of that to this process. And the key points really in relation to that is that the NPSUD requires the panel to have regard to that document in clause 3.7 of the NPS. And you have to have regard to it in relation to changing any RMA planning documents, which includes this plan change process. And the case law tells you that have regard means give genuine attention and thought to. In the most recent East-West Link case in Auckland says you can't sort of simply consider it and then put it to one side. You do have to think about it. But ultimately, it's the panel's decision what weight it gives to the FDS. The panel also asked some questions about Plan Change 30 and potential overlap, and that's something we're still in discussions with on the airport and are hoping to file a joint position on that. And I think the date we were given was tomorrow. So there will be submissions coming in on that a wee bit later than today. And then the last topic you had asked about was Plan Change 28 and the overlap between this plan change and that one. As you may be aware, Plan Change 28 is a private plan change that was accepted by council, not adopted by it. So it doesn't have the status of a proposed plan and it has no legal effect until it's made operative. But it involved a proposed rezoning out in Maitai Valley from a mix of rural and rural high density small holdings to a variety of other zones, residential, open space and suburban commercial. It's currently before the Environment Court. An interim decision has been issued directing further drafting to be done by the parties. A joint witness statement's gone in and that process dealing with those directions. You'll see I've set out in the legal submissions why I say the scope of Plan Change 29 did not include that Plan Change 28 area, and it was not intended that Plan Change 28 is subject to Plan Change 29, and the Section 32 report I think is quite clear in relation to that. So in my submission, the panel probably needs to be clear about that when it makes its recommendations. And you'll see the joint statement that came in last Wednesday from Ms Morgan and the planner for that private plan change applicant has set out a couple of options as to how that could be done. And I guess from a legal perspective, both are appropriate. So I didn't have anything more to say, but you may well have questions.
No, thank you, Ms Anderson, for that. I've certainly got some questions and I'll hand over to the others. Just briefly on Plan Change 28, I want to thank the parties for the joint witness statement. As I said, I think it's very clear to us that the intent was that Plan Change 28 was ring-fenced out of Plan Change 29. Section 32 makes that very clear. And I think the only residual issues seem to be some of those broader provisions which may or may not apply. And of course, it's before the Environment Court. As you say, it has no status. So right now it's not before us, as I understand it, other than there are those broad objectives and policies. I think, and it's going to be a matter of timing as well. I don't know when the Environment Court is going to make its final decision on that, whether that's before we report on this process and the council makes a decision. So it is one we just keep under a watching brief. I don't think it's any great moment. I just think it's on our radar. We understand that there are potential issues. And I think the same applies to the overlap between PCs 29 and 30, while there were clear overlaps which we need to resolve, I don't think any of those are fatal flaw to either processes. I note that Mr. McFadden, I think, has lodged some submissions in relation to that. But basically saying that it's not remediable, is that a word? You can't remedy it through submissions but anyway, we'll wait for your legal submissions and see where that lands. But again, it's clearly on our radar. We need to make sure that any recommendations that we make, and I'm not sure what the delegations are for Plan Change 30, and what Ms. Aitken's panel determines on that. So anyway, they're both on our radar, but we look forward to those legal submissions. So I just check with the other questions. You got? No, you other legal.
Just one. Thank you very much. Just on that matter of the FDS and the relevance of the FDS, and having regard to the FDS, and in your legal submissions, you referred to case law and concluded that it's ultimately, having had due regard, it's ultimately the panel's discretion on what weight it should allocate it. And then quoting the Supreme Court in the East West Link case, I think, where they're referring to Justice Powell's decision in the High Court, where it says that those duties do not invest consent authorities with a broad discretion to give genuine attention and thought to directive and policies, only to then refuse to apply them. But it's still your submissions, isn't it, that ultimately, with due regard and consideration, we weigh them as we see fit and make a decision, having had regard.
That's right. And that quote that you pointed to me to is specific about directive policies. And I think in light of what that case was about, that's policies that are very specific, like the avoid category that we think of. So you do have to take it in that light. But yes, ultimately, it's your decision.
Okay. Thank you.
Ms. Anderson, some of these, you might not know the answer to some of these questions because they're broader council issues, but if you don't, you might get instructions, but they're not determinative. First of all, just we've got Plan Change 29, and it's clearly come out of a response to what's been referred to as a housing crisis, and because the full district plan review was put on hold pending the new legislation, which has of course now been repealed. Do you know when the full district plan is likely to be notified?
That is not something I'm aware of, and I'm not certain whether there is a date for that, but I can check on one of the officers' report back.
Okay, we'll come in. The only reason I'm asking the question is because a number of submitters have raised issues about, and a couple of the experts have saying, look, in the next plan change, you could pick up this. So I was really just interested to know when the council might do the full review, and clearly there's been effectively an exposure draft which has gone out, public consultation document, which was quite detailed, and as I understand it, the council is getting pretty close to having that ready to go. So whether that will come out within the next year, 18 months, 2 years or 6 months would be useful to know. But arising out of that, I want to come to the regional policy statement, and one of the reasons we sort of posed the questions and we set out in that direction is a number of submitters have either explicitly or more implicitly raised there's been this lack of sort of broader strategic overview in terms of an intensification for Nelson, and that Plan Change 29 has the potential to fundamentally change the face of Nelson, make it quite different. And parties are saying, if we don't think we've had the opportunity to have a proper debate at this higher level, the Section 32 and the evidence from the officers clearly says that Plan Change 29, they say, gives effect to the RPS, and that'll be a matter of question. But then the question I've got, and again, you might not the answer to this, do you know why, or was there a clear rationale why the RPS was not contemplated to be changed at the same time as Plan Change 29 to effectively run a companion process? And I just know that Auckland, and Ms. Morgan will be familiar with that because she was a submitter to the Auckland Council's plan change on the RPS and on its IPI. Is there a rationale why the RPS wasn't changed?
I'm not aware of what the rationale was in relation to that, but equally I'd say it's not relevant to the Plan Change 29 determination because the RPS doesn't have to be reviewed to give effect to the NPS.
No, I accept that. I accept that's the legal answer. But I'll put this question to you. What would be the situation if the panel found on evidence and submissions that Plan Change 29 did not give effect to the RPS? Is the panel, and so therefore that section of that can't be met, is the panel then bound to make a recommendation to the council that must reject Plan Change 29, or can it leapfrog the RPS and go to the NPS, because the whole basis or Plan Change 29 is predicated on giving effect to the NPS National on Urban Development? What's the position? What's the legal position there?
I think that really is that Royal Forest and Bird case referred to, that you can't just leapfrog. You need to look at all of them, and at the end of in an ideal world, I think the RMA's written that everything is given effect to, and I suppose the legal answer is it doesn't lead to an automatic decline if you decide something is inconsistent with the RPS, because there may well be an ability to change it, to make it so that it does give effect to the RPS, and that'll depend on scope, submissions and scope of the plan change. So you do need to be able to give effect to both RPS and NPS.
Right. So your submission to us is you can't leapfrog the RPS. If we found that the RPS was not given effect to, we're probably down the track of having to recommend rejection on that basis, unless through submissions Plan Change 29 can give effect to it in the way that the panel sees it. But we can't leapfrog the RPS and go straight to the NPS.
So it's an interesting question, because the case law says you can't leapfrog, but the case law doesn't say, when you look at that plan change test, we've obviously got 2 pages of things you need to apply to this plan change. What happens if you don't meet one of them? There's actually nothing that's I'm aware of that gets specifically into that. So I think the strict legal answer is it has to give effect to both.
Right. Because, I mean, you'll be more familiar with me. I understand the King Salmon decision, which, you know, other than the things that you've covered off, King Salmon clearly set out, you know, there is a hierarchy, and there is a hierarchy of that falls out of the Act. You know, we've got the national policy statement, the RPS, and then plans, and each successive layer has to give effect to the other one. Hence the question we posed about, does the RPS, given that the council says Plan Change 29 gives effect to the RPS, did that mean therefore that the RPS has to be must by effectively by definition have given effect to the NPS? Because I think it's very difficult for a 1997 RPS to have given effect to a 2020 document, which is, you know, that national policy statement on urban clearly didn't exist, and again it fundamentally changes the face of how councils are to do urban planning in my view, and it addresses all sorts of issues about much greater intensification, more is more, and we'll come to that with some of the economic evidence, you know, about at least sufficient capacity, so no longer are councils having to match supply and demand, and also it talks about urban intensification. I was looking at the Nelson RPS, and it barely mentions intensification. It talks about urban expansion, hence why these question marks started appearing. I'm not sure there's a question in there. It was more of a...
Yeah, I mean, I don't think anyone disputes that obviously the RPS has not been reviewed since the NPS came out. That's obvious from the dates of the various documents. But that doesn't mean they're necessarily inconsistent with each other. And if, you know, it is broad principle, the example you've given, the RPS doesn't really address the matter, then you can go straight to the NPS, can't you? Because it's not that you're not giving effect to the RPS, it just doesn't deal with the issue. So you move to the next one, it does deal with the issue, and you apply that.
All right, okay.
So it will be quite fact specific, I think, as to what you're looking at. But I mean, the advice I've had from the planning experts is that the RPS is not inconsistent with the NPS, but it will use different language because of the timing differences.
I noticed that in the section 32, I think at one point it talked about not inconsistent, and I was wondering if that was the appropriate test, and I'm not sure whether it was just sort of loose language or, I mean, clearly at the introduction it's clearly said give effect to. Ms. Morgan can cover this off in her evidence because she addresses that. Thank you for that. I just wanted to put that there because I think we're going to get, I've got some other questions of the experts, and I know other submitters are likely to raise it, so I wanted to sort of fair and square in the public realm here so we can kind of use that as a discussion point. Coming to scope, let's just come to the future development strategy in a sense, because kind of logically falls out of that. I think Ms. Morgan in her evidence says we should give, to use the word reasonable regard, I think quite a lot. And I think your legal submissions are clear. I agree with them. It's for the panel to decide how much weight to give it. Clearly, the FDS is a relatively new document. It's clearly set out where intensification is likely to occur. As you know, through the National Policy Statement on Urban Development, future development strategy then has to have an implementation plan. Do you know where that implementation plan is at? Ms. Morgan might. I mean, so I'll come to that. So because the implementation plan, or what we will do, sort of sets out how the council is going to manage intensification. There was going to be some structure planning. There was going to be sort of neighbourhood plans, and I note the document talks about that can be done at the same time or after. So the question I was really putting forward in terms of how much weight do we give it is clearly set out the broader intensification framework and where in broad timeframes. But it also sets out sort of the methods by which it might be done, which, as I see it, haven't been done yet, but I might be wrong. And when you say it's up to the panel to decide, so we would need to decide their element. We might say, yes, the FDS clearly is, Plan Change 29 is attempting to clearly give effect to that or address that, but the delivery mechanisms haven't been achieved, but that's all right or that's not all right. That would be a matter for us to determine.
I think that's right, but bearing in mind that the FDS is a 2022 to 2052 document, I wouldn't expect everything that's in there would have been implemented at this point in time. And as I understand it, there is an implementation plan completed, but where it's at in the implementation of it, I'm not 100% sure. The council officers will be able to answer that. But I mean, I think you're right. It's a document that is something more than just a straight strategy document. Is directed by a national policy statement. It's made using the SCP process. So you do have to have some regard to it. I'm not suggesting that it's determinative in any fashion, and you don't have to give effect to it. So it's lower down the ranks than the NPS and the RPS.
Yeah. No, thank you for that. Again, submitters have raised it, so it's useful to have the discussion now. So coming to the scope issue, and thank you, and thank you for setting out your legal submissions, and Ms. Morgan. I'm quite familiar with scope arguments, and again, decisions that I've been involved with, certainly in the Auckland context, have made quite significant findings on scope, some of which the council didn't agree with and submitters. And I think, Ms. Morgan, I'm not sure if you would appeal with one of your clients or not on scope. So I understand the issue of scope. But a couple of specific cases, which again, you might not be able to comment on, but you might be able to comment on the principle, and we'll come to the witnesses. For example, the Manukau Street Hospital in the Schedule Y, which Ms. Baker raises in her 42A, which seems to be in her later statements kind of comfortable with where it's got to. But in terms of strict, and again, it's going to be a matter how strict you apply scope. So the Manukau Street Hospital, for example, as you might be aware of, wanted a separate zone for hospitals, and they've kind of come back to the schedule to take it really outside of Plan Change 29. So as I read that, it's not strictly on the plan change. Plan Change 29 didn't look at giving bespoke provisions for anything else, but maybe the impact or the effect of it doesn't undermine Plan Change 29. Where would you sit legally on a matter like that? How strict do you think we'd need to interpret that?
Yeah, scope is a difficult one, and if you've ever been arguing it in the Environment Court, it's the court doesn't like getting into scope arguments or dealing with them as preliminary issues. But coming back to your Manukau Street Hospital example, I have actually had a look at that because I see the JWS did start with this as a legal scope issue. So I did have a look at that. That site. So in my submission, that site was subject to change as a consequence of Plan Change 29, whether it was through a specific schedule or through some other means, I would say doesn't matter. The question is, was it subject to change? What was the extent of change? And does it lie somewhere in that spectrum? And I think Ms. Barker will be talking you through, I guess, the differences and the changes between what's proposed under the schedule and what was in Plan Change 29. And I think when you look at that, particularly in a table format, in my view anyway, I think there is scope to make those changes.
Right, thank you for that. And just one other specific one comes up in the natural hazard, this whole issue of functional and operational need. As I understand it, and again, this might be a detail that you know over, but it's the principle. has sought to be introduced by submission. Functional operational need are definitions in the National Planning Standard, so they're not to be changed. That's not the point. The point is they're recommended to be included. And from a scope point of view, would those definitions need to be limited only to the spatial extent or the year of Plan Change 29 and not more broadly across the whole plan? Because functional operational need, I'm not familiar enough with the whole plan to say, would that have implications, say, in other resource consenting processes where functional operational need was suddenly in play but had not come through a full notification, had come through a submission to Plan Change 29?
Yes, in my submission, you are limited to the spatial extent in terms of scope. We're not talking about a plan change that I guess was changing boundary area boundaries or anything, which sits in a different category. So I think the spatial extent, you are limited to that, because you could have all sorts of unintended consequences if it applies outside of the, I guess, zones that are affected by this plan change.
Thank you. That would be my view. I think that's why I wanted to ask. No, that's fine. Thank you. Yes, Chair.
Thanks, Mr. Chair. Yeah, thank you. Two clarifications, really. So just in terms of the RPS-NPS relationship, just so I understand, you're saying that where both documents deal with a common issue, it's your view that they're not inconsistent at this time. Where the RPS was silent on an issue, we could refer up the NPS for guidance. Is that summarising your advice?
I think that's right, but in terms of your first point, if both documents deal with the common issue, they would need to be dealt with in a similar way for it to be okay. If they deal with them in entirely different ways, then you're probably in that category of is there tension that needs to be reconciled, of which you then resort to the NPS to do that.
Yeah.
But otherwise, yes.
Well, are you saying we resort to the NPS to do that, or are you saying we may be in a position where we would not approve the plan change?
Well, it's interesting, isn't it? Because the Supreme Court never got there. It just said, if you look closely at these things, often there isn't a tension when you examine them closely. Then if there is a tension, you resolve them by looking at the NPS.
Yeah.
It didn't really consider the option of you can't resolve them. But I think, I mean, technically you're right. If you get to that point where you can't resolve the tension, then you can't give effect to one or the other, depending where the tension sits.
Thank you. With respect to the Future Development Strategy 2022, which is, I guess, been part of the Council's planning process subsequent to the NPS and the RPS, so that both those documents are sitting in place at the same time that that's been promulgated. As you say, we have regard to it, we give it appropriate consideration and weighting. But in terms of weight, that's our call. But at the same time, it's a fairly recent document that's been developed in light of those other documents and other factors affecting the district. Yeah. Is it your submission that it's not something that should be given insignificant weight in terms of getting random planning outcomes?
I think that's right. You would expect there to be a consistent vision, considering, I guess, how closely related they are. And I agree with Ms Morgan's comments in her 42A about the reasons why you should give the FDS reasonable weight.
Okay, thank you.
Yeah, I just in relation to the NPSUD and essentially the sort of concurrent process where we've had the Minister signal quite specific changes to the NPSUD that are being worked on, specifically relating to the matters in Plan Change 29, is where would you be finding that sits? Obviously, it depends on the length of time that this process takes, but should there be subsequent amendments to what is a higher order planning document directly related to our consideration, how would you suggest the panel engage in that?
Yes, it's a tricky question, isn't it? And so many things are a bit of a moving feast at the moment. So my submission is you have to apply what's in effect at the moment. The point in time it might become an issue for the panel is if something new becomes in effect before you issue your report. And I guess you have to cross that bridge when you come to it, but it may be that that then has to be considered at that time, whether that result requires some further hearing time. Unclear, depends what the changes are and the timing of it. So you're right, it could be relevant at some point before you issue recommendation, but I'd say at the moment what's proposed is irrelevant until it has effect.
Just a comment, that's always the nightmare scenario for all of us and panels, particularly, the national policy statement on fresh water seems to be changing all the time, and everyone's rushing to get their decisions out before you get another change, so you have to go back and revisit it. So yes, just kind of watch the space really.
And you usually have some warning. I mean, for example, the NPS HPL got amended early August and it's coming into effect on the 14th of September. So the same might be applying, because you usually get a few weeks to know it's coming and what the actual change is.
Thank you very much, Ms. Anderson. Are you staying through the day, or are you?
I am, and I'll
Right.
be here till the end of the council's
Presentation, right?
Presentation.
Because arising out of some of the other evidence from the other officers, there may well be legal questions arising. So thank you.
Thank you.
Thank you very much. Welcome, Ms. Morgan.
Good morning. Harry, are we able to bring up that presentation, please? Yes, good morning. I'm Rachel Morgan. I'm a consultant planner working for Nelson City Council for Plan Change 29. I have been working on behalf of the council for about the last 5 years on a range of projects. So that includes the future development strategy, as well as some targeted work on the draft Nelson plan as well.
You down the back hear us fine? You're right.
Yep. Okay. So I have a brief summary presentation to take you through today. I do have some speaking notes which I can provide as well at the end. So I'll just firstly go through an introduction and overview of the plan change itself and some of the key changes that myself and the Section 42A officers are recommending, a brief overview of the policy context, and also take you through some of the key issues addressed in the 42 and my 42A. Focusing on the relevance of long-term demand projections to the plan change and the zoning in particular, as well as the zoning strategy. I won't talk to the issue of the integration and land use and infrastructure specifically, but happy to take questions on that. And also, as I go through, happy to take questions as I go. So up on the screen is the 42A reporting team. I won't go through that other than to say there are some joining us online today. So Lawrence McIlrath is online, as is Damien Valupalai today, and Heike Lutz as well. And there is, as we talked about earlier, there is a bit of overlap between myself and the others. So we're here to take questions as needed. So in terms of the policy context, I've set this out in sections 4, 5 and 8 of my section 42A report. And there's also further detail included in section 5. But in summary, the primary purpose of the plan change is to amend the NRMP to give effect to the National Policy Statement for Urban Development, with a particular focus on implementing Objective 1 and Policy 1 around well-functioning urban environments, as well as Objective 2 and Policy 1 and 2 around sufficient development capacity. At that more detailed level, the plan change is also seeking to implement Objective 3 and Policy 5, particularly as it relates to the heights and densities enabled through the zoning strategy, which I'll talk to shortly. In doing this, the plan change is also seeking to address Section 6 matters as it relates to heritage and natural hazards. So as we've just been talking about, the plan change must also give effect to the Nelson RPS. And as you've mentioned, it is a first generation RMA policy document, and there isn't a lot of direction in there on urban development. The exception to that is really Chapter 6, which deals with development and hazards. But as you've noted, Commissioner Hill, that is really focused on peripheral urban expansion. Nonetheless, Appendix 1B of the 32 report does go through that analysis. It is reasonably high level and concludes that the plan change does give effect to it. But there is also recourse there to the MPSUD as well, particularly as it relates to well-functioning urban environments. So certainly from a planning perspective, myself and I know the other reporting officers have considered both in developing the plan change. So in terms of the Nelson Tasman FDS, it's also a relevant document to consider, and as I've set out in my 42A, in my view it should be given a reasonable degree of weight, given that it has been recently prepared and under the MPSUD. And particularly as it relates to the aspirations that are set out in the objectives of the FDS, which talk about a consolidated urban form that prioritises intensification in Nelson. But as I'll talk about shortly, there's been further work that's been undertaken as a next step beyond the FDS, which in my view gives some flexibility about how that's implemented in the detail. So in terms of the notified plan change, the key components really include the introduction of the 3 new residential zones that you can see on the plan on the left there. The general residential zone is the most expansive area in that light yellow colour, excuse me, enabling that typical suburban residential development of up to 2 storeys. And just to note there that that is significantly more enabling than the operative residential zones, as it removes the density standards and applies those more generous bulk and location standards, and Mr Wallace and Ms Barker will talk to that in more detail. It also introduces the medium density and the high density residential zone in areas around the inner city and Stoke in particular. And as Mr Gopinath will talk about in more detail, proposes to increase heights in the inner city and suburban commercial centres, and rezones the Vincent Street, Vanguard Street area from industrial to inner city, which is akin to a mixed use zone of sorts. And hand in hand with this is really the increase in heights and densities are the additional standards and design assessment requirements for 4 or more residential units and new buildings within the commercial areas as well. And as others will talk about today, a range of amendments are proposed to the heritage schedule and the natural hazard overlays. Ms Anderson has already talked about the areas that are excluded from the plan change, which you can see through here, and that includes those areas to the north of the city centre around the wood, and primarily in these flatter areas around Te Hunanui, and that's really related to natural hazard matters. Right. So in response to key issues raised in submissions, there are some key changes that have been recommended, which I'll talk about shortly. So I might just skip through this, and Ms Carter will talk tomorrow about some of the amendments that are proposed to the geotechnical overlays and rules as well in response to submissions. So then just turning to the first issue around demand projections and zoning, a range of submitters, and I see there is some submitter evidence or notes on this point as well. They queried the basis for Plan Change 29 in terms of the population and growth projections, and I've responded to that in section 10 of my 42A report. And Mr McIlrath will be online shortly and will be able to talk to this in more detail. But I think there are just a couple of planning points to highlight. And the first one there is that the council's recent housing and business capacity assessment, which was completed earlier this year, it gives us that demand number that we're working to for Plan Change 29, which is around about 7,595 residential units. And that is based on a medium growth outlook or a medium growth scenario. And that is an increase from the previous HBA that was completed in 2021. And I think it just really highlights that these projections are fluid and they do change over time.
Just clarify then. So in the FDS used the high, didn't it? Right. So again, this sort of just came back to that. This, about weighting and all that. But your position is, in some respects, it doesn't matter, given your next point, the at least kind of argument.
Yeah. Yes, that's right. And I think because the FDS is a strategic and long-term urban supply strategy, it is appropriate to use a high growth scenario in that context because it gives the councils flexibility to either hold back or bring forward capacity or supply as it's needed over time.
Yeah, thank you. And I guess in the opposite direction is your same argument applied to the submissions by Mr. Hayes, for example, in terms of it being an overestimate of growth. Is that your same argument that it's an at least provision?
Correct. Yes, and there is just inherent uncertainty in the projections, and Mr. McIlrath will talk about that more shortly. So in my view, policy 2 is really encouraging a greater supply in order to cater for that uncertainty. So in terms of the zoning strategy, those demand projections are highly relevant, as I've mentioned, but they aren't the only consideration. So building on the discussion we've just had, I have not sought to match demand and capacity through the zoning strategy, and there are a range of other relevant factors. So that includes the Policy 1, the need to provide for a variety of homes that meet needs, and also importantly Policy 5, which is reasonably directive in terms of ensuring that heights and densities are enabled commensurate with that level of accessibility or relative demand. So it's indicating that there are broader considerations at play. Those natural and built environment factors, again, are relevant, as are those Section 7 matters around the efficient use of land and the maintenance and enhancement of amenity values, but within the context of what the planned urban built form is. So in terms of the notified zoning strategy, that was informed by 2 key factors. The first being the strategic accessibility analysis undertaken for the FDS, as well as some catchment mapping from key centres. And that was set out in the Urban Design Considerations memo that was attached to the Section 32 report that Mr. Wallace prepared. There was also some development capacity analysis undertaken, which really focused on plan-enabled capacity, and that did consider a range of different zoning scenarios, as well as, of course, the natural and built environment factors that I've mentioned. So, in response to those submissions, that raised issues with that analysis. Both Mr. Wallace and Mr. McIlrath have undertaken much more detailed accessibility analysis of Nelson's urban area, and Mr. Wallace will take you through that shortly, but that has been a key driver in the additional zoning option that I talk about. And Mr. McIlrath, in response to that, has assessed the development capacity enabled, both the plan enabled and feasible as well. So arising from that is the additional zoning option. I thought it would be useful just to briefly summarise this. So firstly, the additional zoning option, which I support and recommend, seeks to retain the heights and densities in the inner city fringe, Stoke and suburban commercial zones. So generally that's about 6 stories. The heights do vary in metres, and in the suburban commercial zone, the heights vary there from about 6 stories to to around about 3 as well. But the key component of the zoning option really relates to the high density residential zone. So the proposal there is to delete the high density residential zone and replace it in some key areas with medium density, generally focused around the inner city and Stoke, and the general residential zone in some instances. So that includes the area around Te Hunanui and the Hampton Terrace block. And the key driver for that change really comes from the outcome of the accessibility analysis. So in replacement for the high density residential zone, I support the inclusion of what we've called a high accessibility overlay, and that enables high density to occur. And Ms. Barker will talk to this in more detail, the mechanics of the approach. Enables high density to occur on larger sites, so 1,000 square metres or more than 24 metres in width, in the most accessible locations, which you can see in that hatch there. There are also a couple of areas where the medium density residential zone is proposed to be reduced in those less accessible locations. So the key ones there are around Te Hunanui, Atawhai, the Brook, Mount Street and Washington Valley. So this is the last slide, and look, I'm not going to slavishly go through this, but it's really just to highlight the summary section 32AA analysis that I included in my 42A report and in the addendum as well. And I think the points that I'd make here is that both the notified zoning option and the additional zoning options do perform relatively well in terms of providing at least sufficient capacity. And they do both enable a variety of housing choices and support improved housing affordability. And Mr. McIlrath talks about the weighted average prices under both options reducing by a factor of about 25% compared to the notified zoning. So on those parameters, they're reasonably equal, I would say. Where the differences emerge is really in relation to Policy 5 matters and matters of amenity values. So in relation to Policy 5, the recommended zoning or that additional zoning option better gives effect to Policy 5 in my view, because it reflects the outcome of the more detailed accessibility analysis which has been done. Acknowledging that what was in the notified was based on that more strategic level analysis. And in relation to amenity values, as I've noted there, the additional option really targets those high density residential opportunities to larger sites in those locations that are both accessible but have the ability to better internalise those effects and achieve quality living environments. And I've included the relevant district-wide objective references there as well. So I might just leave it there and over to questions.
Before we hand over to Mr. Wallace and Mr.